Hi, my name is Goldman. I'm the director and founder of Goldman and Associates. Our firm has a primary focus on family law issues here in Michigan, and today we're continuing our video series designed to educate and inform the public, so please subscribe to our channel. Today I want to talk about the process of obtaining a restraining order in a domestic violence case. Now, let me explain to you that when I'm talking about a domestic violence case, I'm referring to a case where somebody has been charged with the crime of domestic violence. So not necessarily a case in which someone happens to have domestic violence going on in their house, but I'm talking about a charge, domestic violence, where somebody's been arrested and charged with that. In that scenario, there is a mechanism set up by the court to keep the parties away from each other so that no one will be in harm's way. The court enters what's called a no contact order, which essentially says that the victim will be protected from contact with the other person because the other person who's charged with the crime is ordered to stay away from the person, to not call them, to not text them, to not in any way establish any kind of contact with them whatsoever. Now, you can look at this and say, well, that's a good thing. Well, yeah, maybe it could be a good thing. It just depends on how it was initiated. Let's remember one thing. In a charge of domestic violence, it's not one person versus the other. It's not husband versus wife or vice versa. It's the people of the state of Michigan or the people of the city of Rochester Hills, for example, versus the person who's accused. So that means that it's possible that the charge may have come about not as a result of the complaint of one of the people who are party to the marriage. It could have come about because a neighbor called because they heard a fight going on. It could have come about because a police officer happened to see two people driving by and see two people fighting. So it may have come about under circumstances where, for example, the wife doesn't really want a case to go forward against her husband. They had a fight. It wasn't a good fight. It wasn't a nice thing, but they didn't want it to go to the point of prosecution. Now there's this no contact order, which means there's no way to establish any communication at all. Maybe wife needs husband's help taking the kids to school, coordinating things, paying the bills because she doesn't work and he does. How's she supposed to get money from him when there's a no contact order? So the no contact order in the context of a criminal case is a very, very serious thing. And sometimes it's put in place to protect someone when in fact it could be the cause also, while it may protect, of a tremendous inconvenience associated with the case. And in that scenario, oftentimes somebody will have to go before the court and file a motion to lift the no contact order. And I've seen this happen many times where the people will say, look, I didn't want the original charge. Yes, we had a fight, but nobody got hurt. We were both yelling at each other, and some neighbor called the police, and now I can't speak to my spouse. And I don't want any of this. And the court, after establishing that the person doesn't feel that they're in any way in jeopardy, will often lift the no contact order so that the parties can resume a normal standard of life that they had in their marital home. If you have any questions about your particular case, of course, reach out and we'll be happy to help you out.